Good morning, Van Buren. We're waiting for the attorney to sign on.
Good morning.
Hi, how are you?
Morning.
Good morning. What is
Crystal,
your
I'm gonna put you in a breakout room with the department.
Oh, okay, great.
All right, Chris, on the other list.
Okay, perfect. Thank you so much.
Thank you. Van Buren, do you know how to mute and unmute on your end?
My remote's not working, so I'm doing everything through a keyboard.
Okay. Just asking because we are live on YouTube. The attorney needs to speak with our other defendant who's at Romulus before we're gonna hold the arraignment. So if you're not
I
able to
think,
unmute,
yeah, I think you can mute me, yeah.
okay, can you unmute though once I mute you?
I think it like goes 30 seconds and it unmutes itself once you unmute me.
All right.
But I
Okay.
can try it if you wanna.
That's all right. I'll
try.
go ahead and put you on mute and we'll figure it out and get it turned off when we need to get it turned off.
Okay,
Thank
okay,
you.
thanks.
Yeah.
Romulus and Van Buren, I have let the judge know that we're ready, so the judge should be here shortly.
Van Buren, are you able to unmute or no? If you can try, because the judge is coming out. Judge, we'll handle Romulus first because Van Buren's unable to unmute.
All right, you got files?
Good morning.
Good morning.
Good morning, Council. Your first, please.
Crystal Marie Medina, Your Honor, we are handling Mr. Dustin Peterson, correct?
Yes.
Okay, with regard to the arraignment, Your Honor, we would waive formal reading and stand mute.
Thank you very much.
Thank you very much. Mr. Peterson, you can hear me okay? Yes.
Thank you. All right, Ms. Medina, we're looking at a probable cause conference date, courtroom 3, May 31. Let's talk about bond, please.
Your Honor, I did have the opportunity to speak with my client. He indicates he understands he is to come to court, Your Honor. He understands he is to have no contact with the complainants in this case. He indicates he is not currently on probation or parole. He has been employed with G2 Security at the airport since approximately November 1st, Your Honor. He is expected to appear at a shift today at 2 p.m. at the airport, Your Honor. He is 24 years old. I was a little bit confused with the recommendation by police department because it seems to indicate that there's no objection to a personal bond, but then there are other things marked that would indicate otherwise, Your Honor. I would be asking that we give Mr. Peterson the opportunity to be released on a personal bond. He indicates that he is unable to post a monetary bond at this time, Your Honor.
Yeah.
The way
Yeah,
I
the way
read that,
I read that,
the way I read that, they're asking for no contact.
no contact.
Okay, thank you, Your Honor.
And
Counsel, it would probably be helpful if you viewed it.
Thank you. All right, Mr. Peterson, I'm going to put you on a personal bond with a couple of conditions. The first one's the obvious one, stay out of trouble. Second one, participate in your court date with Judge Green, courtroom 3 on May 31 at 9:15.
Okay.
And lastly, I'm going to order no contact.
Okay.
That means no contact with Claudette McKinney, no phone calls, no letters, no social media contact. You run into her at Burger King, you're eating at Taco Bell. Don't have your friends check on her. She contacts you and begs you to meet for coffee. She can't change this order. Only myself or another judge in the 34th District Court. You understand all this?
Yes.
Are you going to be able to abide by these rules?
Yes.
Raise your right hand for me. Do you swear or affirm and acknowledge the debt payable to the court amount of $10,000 if you violate bond?
I do.
If you mess up on bond, you're going back to jail and it's going to cost you big money to get out. Understood?
Yes.
Do you have any questions for myself or Ms. Medina before we terminate the meeting?
No, I do not.
Good luck. Thanks, Romulus.
Thank you, Your Honor. Take care. Take care.
Thank you, Your Honor.
And Van Buren, are we ready?
Yes, Your Honor.
Counsel?
Crystal Marie Medina, Your Honor, on behalf of Mr. Bonacero, with regard to the arraignment, we would wait for more reading and stand mute, Your Honor.
Thank you, Mr. Bonacero. Can you hear me?
Yes, sir.
All right. All right, probable cause conference date, May 31, 2023, courtroom 3. That's by Zoom. Let's talk bond, counselor.
Your Honor, we would ask that the court consider a personal bond. Mr. Bonacera maintains stable residence in Sumter. He indicates that he currently has custody of his two daughters, ages 11 and 13, Your Honor. He indicates that he works at Myland Cast Metal. He has been employed there for 3 months and is employed full-time, Your Honor. I would ask that the court consider the non-assaultive nature of the offense. I do understand that there's a recommendation for a 5,000 10%. We would ask that the court consider giving Mr. Bonacera an opportunity to be released on a personal bond, Judge.
Thank you. Mr. Bonacera, anything you want to tell me? Don't feel that you have to.
No, sir, that seems about right.
Thank you. All right, Mr. Bonacera, I'm going to put you on a personal bond. First condition is the obvious one, stay out of trouble. Second, be prepared to participate on May 31 with your Zoom court date. I'm gonna order that you not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription. You understand all those conditions?
Yes, sir.
Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $10,000 if you violate bond?
Yes, sir.
Do you have any questions for myself or Ms. Medina before we terminate the meeting?
No, sir.
Good luck. Thank you, Van Buren.
Thank you.
Thank you, Your Honor. What time is that Zoom meeting on the 31st?
9:30.
9:30. Thank you.
Thank you, Your Honor.
Thank you, Crystal. We'll check in with you later.
All right, take care. Thanks a lot.
Good morning, Rosemary. I understand the attorneys want to talk to me. Thanks. Hey, Tim, can we get these arraignment files back down? Sure. Thanks. We doing all right with jurors showing up?
Oh, yeah, I think we're just fine.
No, that's great. Not a single hard name either. You guys are lucky. On or off?
I'm sorry?
On or off record?
I guess on.
Okay. I should find the
If we're going on
file.
the record, Your Honor, I'd like my client to be present. Is that okay?
Okay.
Okay.
All right, good morning, ladies. Appearances on the People versus Barnes.
And good morning, Your Honor. May it please the Son of the Court, Lee Young, B44626, appearing on behalf of Ms. Sheena Davina Barnes, who is also present.
Good morning. Go ahead.
Your Honor, I just wanted to kind of hash out some of the evidentiary issues before we go through, before we get the jurors in here. Just in, I guess, in terms of some of the witnesses and exhibits identified by Ms. Barnes and her counsel, I'm not clear, I guess, on how some of it is relevant. I mean, as I look at it, the issue in this case is whether or not Ms. Barnes is guilty of violating the Sumter Township ordinance regarding malicious telecommunications, or however it's worded. And so I think some of the witnesses that are identified in the exhibits run pretty far afield from the issue that is before the court. And so I just have questions about their relevance, about, maybe some impermissible character evidence that maybe sought to be introduced, and just
Okay.
kind of keeping
Sure.
the trial in terms of staying on the issue rather than making it a referendum on everything that's happened
Okay.
in Sumter Township.
And I don't have any witness list or anything else. I think Heather might have some of that stuff. So yes.
Yeah, and I can specifically
Go ahead.
identify them. So the witnesses that are identified on defendant's exhibit list are Peggy Morgan, Peter Gregory, Eric Partridge, and a Julius Green. From my review of the police report, it doesn't appear that any of these folks were involved in the issue that's before the court. It appears based on, in my communication with defense counsel a few days ago, that from what I gathered, that Eric Partridge had some sort of contract or relationship with the township that ended. I have no understanding of how that has anything to do with the case before the court today. And as it relates to the exhibits, there were some exhibits identified that relate to some kind of ordinance letters from the building department in Sumter. So I'm not sure how that plays into this call that Ms. Barnes made to Mr. Bowman. And so I just have some questions about
Okay, so
whether that
basically,
will properly come before.
offer of proof. What are these for?
Right.
Okay. In whatever order, the exhibits, the witnesses, whatever you want to, however you want to handle it.
Your Honor, my offer of proof is that, first of all, I can narrow down the witness list after doing some further investigation. The only witnesses that I will be calling on behalf of Ms. Barnes would be Peggy Morgan and Peter Gregory. Those are the only two witnesses, and of course, Ms. Barnes would take the stand on her behalf.
Okay.
With respect to.
Well, hold on. Let's talk about Peggy Morgan and Peter Gregory.
Judge.
I'm assuming from the comments that I got from counsel, this was a telephone conversation that as far as she knows, two people were involved in. Mr. Bowman and your client, correct?
Your Honor, what Ms. Manarino is requiring me to do is to basically give my defense strategy and give her specific details about what the witnesses are going to testify about. I don't think I'm obligated to do that. I did give her a general overview as to why they would be called. And basically, I'm going to summarize it this way, and maybe this will help her better. With respect to the alleged messages that she's being accused of a crime for, those witnesses would testify as to why those comments were made as to some of those messages.
Okay.
And that's relevant to what she's on trial for, those witnesses, and why she made those comments.
Okay.
And so I guess, my objection to that, I think generally is that it's getting kind of beyond the scope of what's relevant, it's getting, and my understanding is that this is going, the intent of the defense is to make this some sort of, referendum on whatever's going on politically and something has gone on. And I don't know that the entirety of the history and the relationship between the parties, because my understanding is that they've known each other for several years, necessarily is relevant in terms of, I think it just complicates the issue for the jury in terms of there's a lot of history between folks involved, and I don't know that it's all necessarily relevant to the issue of August 19th or 20th.
Well, let's do it this way. If this was a bench trial, I would not be nearly as worried about narrowing issues. All right, but it's not a bench trial, it's a jury trial. So for a couple of reasons, I don't want to get too deep in the weeds with things that aren't relevant. Number one, I don't want to confuse the jury. Number two, I don't want to waste the jury's time. All right. So I'm trying to think of an analogy where I think it would be proper to have a third party explain the reasons party A made comments to party B. So for example, if the third party witness says, well, because we'd been talking to A and she was explaining us how she was setting up this, candid camera type phone call spoof, and it was all supposed to be a big lark, and it just got out of hand, that I could see being relevant to give to the jury. If the third party witness is just going to explain how the bad blood developed between the two parties where somebody threatened somebody else, that's not relevant. So if that fits, if my A scenario fits into your defense theme, then pursue it. But if it's the B scenario where you think somehow it's a defense, it's not a defense for me to call you and say I'm going to threaten your ass just to have somebody explain that you've been really nasty to me for 10 years. So if that's the defense, that's not relevant. That's not a relevant thing to put in front of this jury. That's my opinion.
Well, Your Honor, with all due respect to this court, I don't know what the alleged complainant is going to testify about.
Right.
And the appropriate thing to do in jury trials is if the prosecutor hears a question that I asked that she thinks is not relevant, she has the right to
Right.
object.
No, I'm just warning you in advance.
Very well.
Because I know I don't think anybody knows exactly what's gonna come out of the witness's mouth, right? I mean, we might have an idea based on prior conversations. I'm just telling you that I don't think it's proper to go to the jury with somebody to try to excuse, for want of a better term, bad behavior based on bad blood between the parties. The law does not allow that as a defense to an assaultive type crime. I think we can all agree to that.
It depends on how it unfolds through the.
How does it depend?
The complaint.
If I'm charged with assault and battery, for somebody to explain that there's been bad blood between the two of us for years and I just snapped, how does that a defense to assault and battery?
If you're using that as an example, as a defense attorney, I might point out the fact that my client and that alleged complainant have never had any assaultive contact in the past, even though there's been bad blood in the past. I have a right to present that defense.
All right, just understand we're not going too far in the weeds when I think it's not
understand,
right.
But I can
Okay.
trust you. I'm not going back 10 years.
I got you. So let's talk about exhibits.
With respect to the exhibits that I intend to use were exhibits attached to the police reports that the prosecutor would have gotten before I even got it. So I may use some of those exhibits.
Okay.
In addition, Your Honor, I did provide her additional exhibits that I may use during the course of this trial. And she will attest that I provided them to her. And
How many are we talking about? We're talking about 10, we're talking about 100.
just 1 second.
I don't need an exact count, Ms. Young. Just give me a rough
I can give you
idea.
exact count because, let's see.
I have 27 pages of documents provided to me.
Okay, so
I'm assuming some of those are probably multi-page documents.
yes.
Okay.
I'll say one exhibit contains about 3 pages. The second exhibit contains 1 page. And the third exhibit contains maybe 3 pages. And if necessary, the fourth exhibit, it's multiple pages, but I'm only going to ask the complainant about his relationship to this particular exhibit and asked him why he created the sign he had done, and et cetera. So we're talking about maybe a total of 5 exhibits on behalf of the defense, total, depending on what the complainant says.
I'm not as concerned with dealing with those as they come up as I am with testimony, because I can't take the testimony out of a juror's ear to tell them it's not relevant, but I can look at a document ahead of time when we have that discussion. All right, anything else?
That's all I have.
We ready to get started?
Judge,
You ready?
I've never did a trial before, Your Honor.
Heather, you're ready.
And it's a pleasure to do so, but in terms of procedurally, how long do we get for lunch break and what time do we stop and?
That's all up to the jury.
Okay,
I let the jury decide if they want to break for lunch. I'll give them, I mean, I'm not going to wait till noon and then say, you want to stop now or not? I'll let them know at one of our breaks prior to that time.
okay. And we'll go until 4 today or?
We'll go until 10 o'clock tonight if they want to work that long.
Really?
And I have done so. It's been years,
Okay,
but
I'm glad I asked that question.
I've gone well into the late evening hours just because the jury wanted to finish.
Okay, then I will need to contact one of the one witness who I asked to be here tomorrow at 10, but I can do that on break.
Yeah, we're not going to be here tomorrow. We're not going to be here tomorrow. No,
Okay,
this
got
is
it.
not a 2-day jury trial.
Gotcha.
Ready?
Yes, Your Honor.
Ready,
Okay.
Your Honor.
Let's bring them in.
Your Honor, I just have to go grab a full course.
Yeah, go ahead. I'm going to give this stuff back to you. guess I'm right. I just got a frog on my throat. We got everybody, guys? Got everybody?
We got one more coming in, a child.
Good morning, all. You all look so tickled to be here. A couple of things. First of all, I've got the nameplate, so you know who I am. My name is Brian Oakley. I'm one of the judges here at the 34th District Court. You've probably all interacted with either Officer Garcia or Officer Rapp. Anybody else upstairs today? Was Ken upstairs? All right. Officer Brooks was up here. So the security guys kind of rotate in and out. They kind of share duties. Their job is to make sure we're all safe. That's not a concern for me today. So their secondary job is to make sure that you guys have conduit to me. So if you need something, if it's too cold, if it's too hot, whatever, if you need a break at some point in time and you're not catching my eye, just say something to one of our guys and they'll be that conduit to me, and we'll figure out how to keep you folks as comfortable as possible. Heather Mortsfield is my secretary recorder. Her job is to make sure that everything's said on my side of that little half wall that separates us right now. Everything that's said on my side of that wall is accurately recorded. That's important for you to understand, because at some point, some of you folks may be asked a question and you'll have an answer. So if we have two people speaking at the same time, both those voices go into her ears, both of those voices get recorded at the same time, and it's a garbled mess. So I'm going to ask you, if someone asks you a question, make real sure they're done asking before you start answering. And when you do answer, don't answer like this, because head shakes and head nods don't get recorded very well. So I'll ask you to stick with audible answers. So let's do this. How many of you folks, when you got your notice, were real excited about coming in and seeing us today? All right, that's unusual. Usually I get one or maybe two hands that go up. All right, how many of you folks have served on a jury before? All right. All right, ma'am, did you serve locally or downtown? Oh, okay, you're an experienced juror. Okay, when you served locally, was it at our court or had you lived somewhere else? Okay, all right. Some hands are up over here. Back row, downtown or local? Both, wow. Ma'am? Okay, was there another hand? Detroit, okay. Raise your hand if your jury experience has been more positive than negative. Raise your hand. Okay, all right, okay. After some thought, one hand goes up. Okay. Was part of your negative experience just the fact that you had to go downtown, you had to pay for parking, it was probably a major time suck? Raise your hand if that was a major problem for you, or, you know, somewhat of a problem for you. Okay, yeah, that's normally a thing. Did any of you folks have to serve for more than one day? How many days, ma'am? Okay. 3? 6. Oh, yeah, that's a time suck. Yeah, okay, okay. So I've been doing this since 1999. I didn't look at my notes. I think this is jury trials somewhere in the 80s. I've only gone beyond what I'll call a business day, 4 or 5 o'clock, 3 times. Twice we went quite late into the evening, and once we came back and by 10 o'clock the next morning we were done. Each of those 3 times we worked at the pleasure of the jury. And what I mean by that is I let the jury decide how late they wanted to work, and in 2 different cases they wanted to work till 9 or 9:30, I think. The third case, when I said, how late do you want to work? They said, we're wore out now. We'll come back tomorrow. And literally, once we got everything going and we put them into deliberate, it took them less than half an hour to get to a decision. I think they were just punch drunk the night before. So I tell you that to let you know, if you get picked on this jury, you're going to set the tone. If we break for lunch or if we keep working through lunch, that's going to be because the jury decided that's the way they want to do that. Everybody else under here, I make them do what you want to do. Okay? So if you folks want to break for lunch, we're going to break for lunch. I'm not going to give you 3 hours for lunch. Just don't get crazy. But if you want to break for lunch, we'll break for lunch. If you don't want to break for lunch, you want to keep going. And after you keep going, you decide, all right, it's 2 o'clock. That's too late. We got to get something to eat. We'll break for lunch at 2 o'clock, or as you know, close to 2 o'clock as we can to make it flow well with the witnesses and so forth. So if you're not catching the theme is, I understand that most people don't show up for jury duty wagging their tail because they're happy to be there. So what my role is to make sure this trial goes as efficiently and effectively and comfortably as possible. So our staff, that's our goal. We want to make sure that whoever gets served on this jury, whoever's asked to make that decision, we make it as comfortable for you as we can make it, because we understand most people don't wake up in the morning and get real excited about going to court and being on a jury. I will say this. I've talked to each and every one of those juries after the trial was over, and I've also sent out little exit surveys. You know, rate your experience on these questions. You've all seen them, right? 0 is strongly disagree, 10 is strongly agree. Pick a number anywhere on that spectrum. And what I found over the years is most people, even if they've got a real negative experience or negative attitude about serving on jury duty, after they've served, at least for the local courts, it's not as bad as they thought it was going to be. And trust me, I've been called downtown for jury duty too. I spent more on lunch and parking than the per diem that they gave me, right? So I understand circuit court is a different issue. So what I'm hoping is that if you spend the day with us today, at the end of the day, maybe you don't want to do it very often, but at least you look at it as, all right, part of my civic responsibility. It's not as bad as a colonoscopy, so I'll do it when they call me. So with that, I told you my job, one of my jobs is to make sure that we run the trial. And counselors, you can sit down. I talk too much, so I'm sorry. See, in law school, they train attorneys to be on their feet to address a judge when a judge is talking. So it's instinctive for them. But part of my role is to make sure that you folks get the proper information you need if you're ultimately called to make that decision. And in our jury system, a lot of what you need to know are the actual Michigan jury instructions. And I've got 3 volumes like this. Okay? 3 volumes. Luckily, what's in all 3 volumes doesn't apply in every case, so you don't have to hear 3 volumes. But you do have to hear a number of jury instructions. And we don't have the kind of money so I can do like the politicians and pretend I'm looking at you because there's an invisible teleprompter in front of me. We can't do that. And I'd much rather engage with you and look at you while I read to you, but I can't do that. So I'm just going to have to read to you, and you're going to look at the top of my head and my forehead for a few minutes. So I'm going to get started with that right now. As soon as I get to the right page on my iPad. All right. I've already told you who I am. Any of you folks live in someplace other than Huron, Belleville, Sumter, Van Buren, or Romulus? I don't think these guys have missed anybody in years. They screen at the front counter pretty well. I've already explained it. I know that none of you really wanted to be here today, except maybe me and some of the staff. All right. The jury is an important part of the court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both parties who are accused, or the law says that both a person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain the information about you that will help us to choose a fair and impartial jury to hear the case. During trial selection, the lawyers and I will ask you questions. This is called the voir dire. The questions are meant to find out if you know anything about this case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a peremptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I'll now ask you all to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all these questions truthfully, fully, and honestly. Please raise your right hands. Do you all solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? Thank you all. All right, so I've introduced Heather, I've introduced the court officers. I'm going to ask the attorneys now to introduce themselves and at least by name, any prospective witnesses they may call. Ms. Manarino, if you would.
Thank you, Your Honor. Good morning, everyone. My name is Angela Manarino, and I'm the prosecutor for Sumter Township on this case. I have 2 witnesses for you this morning. Tim Bowman, who's the supervisor for Sumter Township, and Detective George Stout.
Ms. Young.
Thank you, Your Honor. And good morning, ladies and gentlemen. My name is Attorney Rita Young. I'm going to be representing Sheena Barnes. She may stand up and say hello to you. And the individuals who I may call as witnesses in this case will be, of course, Ms. Barnes will take the stand on her behalf, as well as I will be calling Ms. Peggy Morgan and possibly Mr. Gregory. His first name is Peter Gregory. Thank you.
Thank you, ladies. Folks, do any of you know any of the people that have been identified? Either you saw them or you heard their names. Anyone? Sir? Okay. Do you know any of those folks personally or just know their names because they've been involved in local politics and so forth? Okay. Okay. I'm assuming that nothing about reading their name in the paper or knowing, who they are is going to affect your ability to be fair and objective today? Okay. All right. And your name, sir? Your name? Mark Welding. Muddleman. Thank you, sir. Anybody else know any of the names that were discussed? Okay, great. All right, length of trial. I don't have any reason to think this is going to go beyond 1 day. Once again, what I mean by 1 day is 4 or 5 o'clock, like a business day. Does that time frame present any problems for any of you? Sir, front row name.
Michael Hale.
Hale? Yes, sir.
Yeah, I have a friend who is in hospital
Right, right.
And hard for me to hear.
Sure. Well, let me tell you, I read just a minute ago, I read about the fact that we have a jury of 6. We're gonna start this trial with a jury of 7. And one of the reasons we do that is for situations like this. If you're one of our 6, okay, and then we seat an alternative, and you get the phone call that your friend's passed and you need to leave, you need to leave. And we're gonna continue the trial with an alternate.
It's just like, I think I should be there every day, because.
Okay. So, I mean, you were there yesterday, you were there the day before, you're basically on death watch, for want of a better way to say it. All right. Ladies, do either one of you have any objection if I excuse Mr. Hale so he can be with his friend?
No, Your Honor.
All right, Mr. Hale,
No objection, Your Honor.
my thoughts and prayers are with his family, or her family. Thank you. Thank you. I think there was another hand over in this side, wasn't there? Ma'am, what's your name? Chesno with a CH? Chesno. Yes, ma'am. What's the issue? Would the length of the trial today cause a problem? Okay. Back room. What's your name? Jackson. Okay. Who's your babysitter when you're working? Okay. All right, well, who did you work yesterday? Who watched the baby yesterday? Okay. Yeah, so maybe we'll call CPS. Let's just see how it plays out. Anybody else? Yes, sir. Oh, I'm sorry. My point wasn't very accurate. Front row. Your name, sir?
Charles Hook.
Hook. That's an easy one.
H-O-O-K, just like that.
Go ahead, sir.
I've got some medical issues going on, and currently, as we speak,
Okay. I don't know what that is. So what's that mean for your ability to be here today?
Extreme pain.
Okay.
Can require me to lay down for 30
Okay.
to 60 minutes.
All right. So is that extreme pain going to affect your ability to pay attention and listen to the witnesses and all the stuff that is required by a juror?
I feel that while I'm under the influence of
Okay. All right. Okay. Well, I appreciate you coming in. Ladies, any objection if I excuse Mr. Hook for cause?
Can we approach her?
Sure. All right, Mr. Hook, you are excused, sir. Good luck with your health issues.
Thank you.
Thank you, Ryan. Thank you.
Yes, ma'am. Your name?
I have chronic migraines and I have migraines right now. And if you have to go puke, I have to go.
Understood. Okay. All right. Anybody else? Yes, sir. Name?
That's wrong.
Williams. Go ahead.
My medical condition is similar to this left. Actually, sent you a message and showed that it was denied, but I'm going through tests.
Let me stop you. Silence your phones, please. Go ahead, sir.
Yeah, I'm going through a series of tests, and I actually have an appointment today with my specialist to go over the test. If I'm not mistaken. Want to do a biopsy next, but I'm actually chronic pain as well. And my issue, if I sit for too long in this position, in my knees, my ankles start to swell.
Sure. All right. And in almost every jury trial, I get somebody that's got back pain, knee pain issues, so on and so forth. And I always do what I'm going to do with you. If you get picked up here, then I'm gonna use you as the barometer. Because I figure you're probably gonna need a break to move around more than somebody that doesn't have any health issues. So it's just like grade school. Remember grade school, right? So just, if you're up here and you just gotta move, let me know, we'll take a break. Everybody can go out and stretch, walk around, do whatever you have to do, just to keep you as comfortable as we can. Understood? All right, okay, thank you. Anybody else? Okay. I'm fairly loud. I'm assuming everybody's been able to hear me okay? All right, everybody's not as loud as I am. Do any of you have hearing issues? No? Okay. So if at any point, maybe a witness or maybe one of the attorneys is speaking and you're just not quite making it out, don't be afraid to say louder, please. I do it all the time. I mean, I get witnesses up here and they're only 6 feet away from me, and I speak up, speak up, speak up. So it's important for you to hear what's going on. So if at any point you can't, just stop, raise your hand, stop what's going on and say, I can't hear witness so-and-so. All right. Any other health issues? Hearing issues, we got that out of the way. Anything? Okay. All right, folks. This is a criminal case. The paper or the document used to charge Ms. Barnes with a crime is called a complaint. The complainant in this case charges that the defendant, Sheena Barnes, charges the defendant, Sheena Barnes, with the crime of malicious use of a telephone and reads as follows. The complaining witness says that on a date and at the location described, the defendant, contrary to law, at approximately 1:38 p.m., defendant Barnes did maliciously use any service provided by the communication carrier with intent to terrorize, frighten, intimidate, threaten, harass, molest, annoy, or disturb the peace of any other person by threatening physical harm or damage to any person or property of another in the course of a telephone conversation. The defendant has pled not guilty to these charges. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal trial so that the defendant and the jury can hear the charges. You must not think it is evidence of her guilt or that she must be guilty because she has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered evaluation of the facts and circumstances. Waiting for the iPad to upload. All right, so let's see, we established residency. We've established that you don't know any of us. Any of you folks have any relationship to law enforcement officers? Friends, family? Yes, ma'am. All right. Local law enforcement? Detroit. All right. So we're not going to hear from a law enforcement officer, at least I didn't hear any identified, correct? We're not going to hear any law enforcement officers testify today?
Yes, Your Honor, Detective Salatin.
Oh, all right. So the fact that you have family that are law enforcement, would that cause you to judge a police officer's credibility any different than you would a lay witness? So you can be fair and objective to the police officer? Okay. Anybody else, law enforcement? Friends, family? Okay. Ma'am? Friends? Officer Salatin? Sumter Township officers at all? Okay. The fact that you have friends that are in law enforcement, would that cause you to be biased either towards the defense or the prosecution in a criminal case? Okay, thank you. And your name was? Thank you, Ms. Schultz. Right. Any of you ever been involved in a criminal case? As a witness, defendant, anybody at all? Okay, wow, that's great. How about maybe civil cases? Anybody been involved in a civil lawsuit where you sued a company or a company sued you or another individual, something like that? Back row, name. Name. Summers? Miss Summers, were you involved in a civil lawsuit or a criminal case? All right. Anything involved in that part of the system that would cause you to be less than objective today? Okay, great. Thank you. Okay. Any of you folks have any, you heard me just read the reasonable doubt instruction, right? Okay. And you've all heard that before if you watch any TV whatsoever. Do any of you have any preconceived notions or convictions or just really strong opinions about the fact that you shouldn't be sitting in judgment of one of your fellow citizens? Anybody? All right. How about the reasonable doubt, presumption of innocence? You've heard those phrases kicked around before. I've read the instructions on those. Everybody's heard the concepts, right? Do any of you think it's an unfair burden to place on Miss Manarino that she has to prove every element of the crime beyond a reasonable doubt? You think that's unfair to her? I mean, after all, she's over here all by herself. Anybody? Okay. All right. Let's talk about innocent until proven guilty. If I had a tea time today, and I don't because I don't golf, but if I had a tea time today and I'm looking at the clock and I'm thinking, man, we got to go. Folks, go with the court officers. I'm going to send you out. Just make a decision right now. Right now. Would you all agree with me that the only decision you could come up with would be not guilty? Would you agree? Because you've heard absolutely zero evidence of guilt, and Miss Barnes walked in here with a clean slate, innocent until proven guilty beyond a reasonable doubt. You understand that concept, right? It's not overly complicated. Are you willing to give her that benefit of the doubt? Because I've talked to people before, it's like, yeah, people don't get charged with a crime if they didn't do something wrong. Well, first of all, something wrong is a pretty broad definition. Would you agree with me? Something wrong could be maybe they should have been in a certain neighborhood at a certain time of night, but they didn't break any laws. Should they still be found guilty because they made a bad decision about where and when? I would say no. Hopefully you would agree. Okay. So do any of you feel just because she's here, she's got to be a little bit guilty? Maybe the prosecutor's already partway home on that. Anybody feel like that? Because if you do, please, you got to get it out. Because the process that we're involved in right now, the voir dire, it's all about making sure that the folks that are seated in this box to make the decision start out blank slates. Just dry sponges ready to soak up what comes out of the evidence box, maybe some exhibits that you look at, the instructions that I give you, and then with all that information in your new sponge, get into the jury deliberation room, make a decision. You all blank slates? Okay. All right. Now this is my favorite question. I've been using it for years. If it wasn't Ms. Barnes sitting right there in the hot seat, she's in the defendant's chair today. If it wasn't her, if it was your best buddy since kindergarten, if it was your son or your daughter, it was somebody you loved dearly, would you want your mindset in the head of each and every juror up here? And if you say no, there's something you're thinking that we need to talk about right now. Does my analogy make sense to you? Okay, so if any of you answered that question in your head, no, please raise your hand and let's talk about it. And I'm not trying to embarrass you. I'm not trying to put you on the spot, but it's very, very important that the people that are seated and sworn in to make this decision on Ms. Barnes's case are clean slates and not biased in any way. Yes, sir. Mr. Williams.
Mr. Williams, I said no because I've been waiting for about 5 weeks for this. When they find what's going on, so I don't know.
That's too heavy on your mind. I get it. I get it. I've been waiting for tests too. I mean, not currently, but in the past, I've waited for tests. I understand how that can weigh on you. Okay. All right. Anybody else maybe answered with a no? Okay. All right. Good. Okay. All right, I think I'm ready to turn it over to the attorneys for some questions. So let's call some people up. Guys, let's do 1, 2, 3, 4, 5, 6, 7. Okay. All right. So I went over the list of names this morning. None of you folks have what I would consider to be difficult names to pronounce. But if Officer Garcia mispronounces your name and you don't correct him, then the attorneys and I are probably going to mispronounce your name while you're here. So please, if there's a mispronunciation, let's correct it so we can at least refer to you by name and pronounce it correctly. Thank you.
Johnson Bowles. Number 16, Johnson Bowles.
And I hate hyphenated names because they confuse me. So is it Miss Johnson Bowles or Miss Bowles Johnson? Thank you. Right up here, ma'am. And watch your step on the incline ramp. Yeah, you have to circle around and take that first chair. Thank you, ma'am.
Number 25, Christy Schultz. Number 31, Jerome Williams.
Watch your step, Mr. Williams.
Number 10, Angelina.
You know what? Let's do this differently. Let's do this. I'll adapt. Why don't you ladies switch out? Ms. Johnson Bowles will put you closest to Officer Garcia right now. Less disruption that way. I'm actually, believe it or not, I'm actually still stuck in the way my jury box was set up in the old building. So I just have to rethink it. Go ahead. Yep. Ms. Schultz is chair 2. Yep. Got it. Mr. Williams. Yep. Next chair. Yep. And I missed the next name.
Chair number 10, Angelina Flora.
Flora, is that right? Welcome. Have a seat, ma'am.
Chair number 7, Michael Aravu. Corvu. My apologies. Chair number 4, Jennifer Bridges. Chair number 8, Alicia Dennis.
Thanks, guys. All right, I want to make sure I got it right. So Ms. Dennis, Ms. Bridges, Mr. Corbu. You say it, say it.
I say Corvo.
Caraveau.
Corvo.
Caraveau. Caraveau. Thank you, sir. All right, Ms. Flora, front row, Mr. Williams, Ms. Schultz, and Ms. Johnson Bowles. All right, okay. Now the rest of you, you're not out of the hot water yet, okay? So what's gonna happen next is the attorneys and I are gonna ask questions of these folks. I want you to answer those questions mentally in your head, because there's a good chance that one or more of these people are going to be excused for some reason or no reason we even know about. And I'm gonna let them leave. One of you may end up in their chair. And the first thing I'm gonna say is, have you been listening to the questions that have been asked of the folks around you? And would you have answered them any differently? Hopefully, so that the attorneys don't have to go through each and every question with you that they went through with the panel, all right? And once again, what we're after is clean slates, fair and objective people that are sworn in to make the ultimate decision. So just pay attention to the questions that are asked, answer them to yourselves if you would. Ms. Mandarin, I'll let you start.
Thank you. Good morning again, everyone. So I understand from when the judge was asking questions for, none of you actually live in Sumter Township, is that correct? Okay. Are any of you familiar with any of the government officials in Sumter Township? Do any of you belong to any Facebook groups involving Sumter Township? Does anyone read the Belleville, the Independent, the newspaper? Mr. Corvo, you indicated you. How often? Have you seen anything in the newspaper regarding Sumter Township that has impacted your opinion of the township?
Nothing really sticks in my.
And which community do you live in?
No.
Okay, so do you tend to focus more on the Belleville news items?
But I don't read it every issue.
Okay. I think that's all the questions I have. Thank you.
Ms. Young, your panel.
Good morning again, ladies and gentlemen. Mr. Corvo, I'm an attorney, I don't know personally, but I've seen the name. Are you related to Joe Corvo?
I don't know him. I think he's a distant cousin. I think his grandfather and my grandfather were brother.
Okay, so I could be assured that you just followed the law and now Judge Oakley will give to you in making your decision.
Yeah.
Okay, thank you. And Mr. Williams, I'm so sorry about your medical situation, and you do believe that that will impact your ability to be focused and listen to the evidence?
I do.
Okay, thank you for your honesty. Has anybody ever been involved in politics, meaning held a political office or a governmental office? Anyone? By show of hands? See no hands? Okay, thank you. And do any of you, oh, I'm sorry.
I work for the federal government, the same,
Ms. Johnson Bowles?
Angelina,
Oh,
Florida.
I'm sorry. Ms.
I
Flores.
screwed you up, Ms. Young. I changed the seating chart.
So I'm not necessarily involved in politics, but I work for the federal government.
Okay, may I ask what section of the federal government?
The Federal Deposit Insurance Corporation, FDIC.
Okay, no, I don't think that will impact your ability to be fair and impartial. And I see a hand by Ms. Bridges? Dennis, I'm sorry. I'm a victim advocate. I work for the Wayne County Prosecutor's Office and I work with. Okay. Thank you for being honest. Do you think that because you work for the prosecutor's office, you would tend to side with the prosecutor rather than the defense attorney, or do you think you're just based your decision on evidence or lack of evidence? I've been doing it for 20 years, so you could be impacted. Okay. All right. Thank you for your honesty.
Ms. Young, I just want to clarify, you've never worked with Ms. Manarino's office, have you?
Yeah.
Okay. Just want to make sure.
I'm just a statement.
No, I got you. I thought so, but yeah.
And then, is there anyone who does not like coarse jokes that involve cursing or obscene language or offensive language? If you are offended by that, can you raise your hand? Yeah, no hands? Okay, thank you.
All right, Ms. Manarino, for cause?
Your Honor, I think based on Mr. Williams' answers about his medical condition, I don't know that he is
Yeah.
a great candidate for the jury this morning.
Ms. Young, any objections?
No objections.
I don't disagree. Mr. Williams, good luck with that test result
Thank you.
and the follow-up.
Thank you very much.
Juror 19, Kayla Marion.
Marion, is that right?
Yeah, that's right.
Ms. Marion, why don't you step over here on this ramp? Thank you, Ms. Flora. It's all about you. Were you answering those questions in your head? Is there anything based on the questions that the ladies asked that we should talk about?
Oh, no.
Okay, you don't work for government, you never been involved in, held a political office or anything like that?
No.
Okay, all right. Ladies, I'll let you ask questions of Ms. Marion.
I don't have any questions for Ms. Marion yet. I don't either, Your Honor, based on her comments.
Okay. Ms. Young, any for cause?
Your Honor, I'd like to thank and excuse Ms. Dennis for cause. Thank you, Ms. Dennis.
And I didn't say this, but you are free to leave.
Thank you.
Did Mr. Williams leave? He already left. All right, so, Ms. Dennis, don't leave yet because I'm going to give you a lecture.
Okay.
So I'll get it out of the way for anybody that might leave here before we're done.
Okay,
No, I'm going to do it right now. If, and I know you don't, but if you need a note to show you were actually here today to convince your employers or a suspicious spouse or whoever, we got a note downstairs. You guys doing it up here or are we doing it downstairs? Cashier. Okay, go to the cashier and we've got a little note that says you were here today for jury duty. All right. The other thing is, if you want to come back when you're not going to be in a hot seat and you just want to see what happens, or even better yet, bring some kids with you to give a little civics lessons, we love to have visitors. All right, now you can leave. You're welcome. I'm sure you will.
Juror number 15, Marvin Jackson.
Bring the baby up, that's all right. I wish they were all that quiet. So, Mr. Jackson, where do you work? What do you do? What'd you do to your hand? I see your hands all wrapped up.
Working on my truck.
Okay. Oh, and you didn't get paid for that. You tore your hands all up and didn't even get paid. All right. All right, so were you answering those questions in your head? Okay. Anything these ladies and I need to know about so we can discuss to see if you're a fair and objective person? No? Okay. Ladies, any questions for Mr. Jackson?
I don't have any questions for Mr. Jackson.
This question is to Mr. Jackson and the other jurors. Knowing your mindset and your personality, what you think about our criminal justice system, would you, if you had been accused of a crime, want you to sit as your juror? Could you be fair and impartial? Anyone who thinks they could not, would you raise your right hand? In no hands, so you think all could be fair and impartial, just base your decision on the evidence or lack of evidence. Okay, thank you.
All right, for cause, ladies, Ms. Manorino.
I have no, Your Honor.
Ms. Young, for cause.
Pass for cause, Your Honor.
All right, peremptories, Ms. Manorino.
I have none, Your Honor.
All right. Ms. Young, peremptories.
Satisfied, Your Honor, with the presently seated jurors.
Okay. All right. Now you folks have dodged the bullet. You can leave if you'd like. You can stick around as long as you'd like and leave at any time when you want to. And I thank you for being here. Thank you for being here. Enjoy your day if you do leave or when you leave. I'm sorry. Let me swear them in first and then we will. Yeah. All right. So folks, I'd like you to raise your right hands. Ladies and gentlemen of the jury, you've been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Here's your oath. Do you each solemnly swear or affirm that in this action now before the court, you will justly decide the question submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court? All right, thank you. Now you can take a break. You can all take a break. Stretch your legs. Yeah. Then we'll get to work in earnest. Try to remember the seat you were in. We'll get you back in the same seat. Yeah, ladies, take a break.
Cute little baby, he's sleeping. Wait till he wake up, I'll be ready to rock and roll. That is so funny. It is. Okay, thank you.
Yes, Adam. You don't have to use the iPad. Were you able to give the instructions the last time? No. Next week when she gets made, and she needs to know it's wrong. Oh, right. No, okay, there wasn't. No, because I think I definitely would have updating last time. Oh, it was Caitlin. Yes. It was Caitlin.
Hey, Jamie? Is Tim still up here?
I know Ken is. Not here, he may be back.
That's all right. I'll just swear you in. Raise your right hand. Do you swear that you will, to the best of your ability, keep sworn jurors in some private place, that you will not allow anyone to speak with them, and that you will not speak with them except under the court's order, and specifically, you will not ask them if they've reached a verdict, and until they are discharged, you will not communicate to anyone the state of their deliberation or the verdict they've agreed upon? Thank you.
The juror with the child had run outside to get it.
That's fine. What did I do? Put 4 iPads out? Yeah, but I got 8 out. What's that?
I'll explain those in a minute, folks.
Did everybody get one of those? All right, folks, those iPads in front of you, you can ignore them, by the way. It's not mandatory, but you've heard me make reference. I'm reading the jury instructions that are off the iPad. The attorneys both have the iPad. If you want to follow along with me as I read, I'll show you how to find where I'm at. Once again, don't feel that you have to do that. I'm an auditory, or excuse me, I'm a visual learner, not an auditory learner. So quite often attorneys, hint, ladies, quite often attorneys will get up in front of me and start to read to me a statute or something they want me to understand. In my mind, I just shut off. If you want it to actually get in my brain, I've got to see it. All right. So this would be very helpful for me if I was in your seat. I'd want to read the jury instructions as they were given. You might be an auditory learner. Reading it might distract you. Once again, use it, don't use it, completely up to you. If you want to use it, the page you're looking at now says Judge Oakley's jury instructions. In very small print off to the left, it says subcategories, I think, or sub-menu. Yes. Sub-menu. If you hit that menu, there's a pop-up or pop-down, drop-down, whatever they call those things. We're currently in procedural instructions, and I'm on page 2. But once again, if it's distracting for you to try to mess with the iPad, just sit back, listen, and I'm going to give you the instructions that you need to hear. All right, but I'll give you a minute to scroll if you want to look it up. So we're going to start with, actually we're at the very, very bottom of page 2 with legal principles. All right, we're ready? I will now explain some of the legal principles you will need to know in the procedure we will follow in this trial. A trial follows this procedure starting on page 3. First, the prosecutor makes an opening statement where she gives her theories about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes hers, or she may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. To prove the charges, the prosecutor must prove the following beyond a reasonable doubt. Oh, no, see, I thought that's where this popped in. No, it's not popping. I thought they did. See that? That would be handy. We should talk to Fred. We should talk to Fred and see if we can do that. Did I? All right. So if you want to follow along with the elements, you got to go back to the submenu and click on elements of the crime. Malicious use of a telecommunications service. The defendant is charged with the crime of malicious use of a telecommunications service. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant used a service provided by a communications carrier to communicate with the complainant, Timothy Bowman. Second, that when communicating with complainant, the defendant threatened physical harm or damage to any person or property of another in the course of a telephone conversation. Third, that the defendant did so with the intent to terrorize, frighten, intimidate, threaten, harass, annoy, or disturb the peace and quiet of the complainant. Then we're hitting some menu, back to procedural information, and going back to page 3. Next, the prosecutor presents her evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all her evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or to produce any evidence. If the defense does not call any, if the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defense lawyer will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. You've been given a written copy of these instructions, well, electronic. You may refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of trial, I will provide you with a copy of the final instructions electronically for you to use during your deliberations. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to the case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. When it's time for you to decide the case, you are only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibit admitted into evidence, and anything else I tell you to consider as evidence. It's your job, going into page 4, it's your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of the witness. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some questions of the witnesses myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. Page 5. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after that, do not ask it yourself. Raise your hand, write the question down, and pass it to the court officer. We say bailiff in the court rules, who will give it to me. Do not show the question to your other jurors. That's where the steno pad comes in. If you want to make notes, you can do that. But inside that steno pad, I think there's 1 or 2 jury question forms that you can just pull out that form, write your question down, submit it to the court office. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with this trial, this case. Pay no attention to these interruptions. You must not discuss this case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. When the trial is over, you may, if you wish, discuss the case with anyone. Page 6. If I call for a recess during the trial, I will either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. But you must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you are not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. Just talk to one of the court officers. You must not talk to the defendant, the lawyers, or the witnesses about anything at all, even if it has nothing to do with the case. It's very important for you to only get information about the case in court when you're acting as a jury and when the defendant, the lawyers, and I are all here. Do not go to the scene of the alleged crime. Do not investigate anything about the case on your own or make any experiments. Do not search the internet on your phone to assist in understanding the evidence in this case. I've already explained to you about the note taking. Once again, take notes if it helps you, ignore that if it doesn't. I've explained to you the number of jurors and why we have 7. Under penalty at the bottom of page 6. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. Page 7. I may give you some more instructions during the trial, and at the end of the trial, I will give you detailed instructions about the law in this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After all the evidence has been presented and the lawyers have given their arguments, I will give you detailed instructions about the rules of law that apply to the case. Then you will go to the jury room to decide your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It's important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. Satisfied with the jury instructions that's given so far, ladies?
Yes, Your Honor.
Satisfied, Your Honor.
Thank you, ladies. Are we ready for openings?
Yes, Your Honor. Thank you, Your Honor. Ladies and gentlemen, the evidence that you're going to hear this morning in this trial is going to indicate that on August 19th of 2022, the defendant in this matter, Sheena Barnes, called through Facebook Messenger the complainant in this matter, Timothy Bowman. And during the course of that call, she made some threats to Mr. Bowman and his wife. Mr. Bowman reported those threats to the police, and that's what brings us here today. Those actions by Ms. Barnes were in violation of Sumter Township Ordinance, and that's the ordinance the judge has read to you this morning. And at the conclusion of this case, after you've heard the evidence, I'm going to come back and talk to you again and ask you to find Ms. Barnes guilty of the ordinance violation. Thank you.
Thank you, counsel. Ms. Jones.
Thank you. Excuse me, ladies and gentlemen. Ms. Barnes ran for the position of treasurer in Sumter Township, in 2022. And now she is being charged with a crime for some messages she sent in private to the alleged victim, Timothy Bowman. The messages included some curse words along with some coarse joking she did in response to comments he made and things he did. As you know, ladies and gentlemen, criticisms, bantering, comments about public matters and about politicians or government officials are part of the political campaigning process. Curse words known as vulgar, obscene, indecent, or offensive language is not against the law. As you all know, people use that type of language every day as a means of communication, as a manner of expression. It's used on social media, in songs like rap music and other types of music, used on TV, and while making coarse jokes. It's not against the law. The messages that are the subject of this alleged crime were not sent by Ms. Barnes with the intent to frighten or to do physical harm to Mr. Bowman or to his wife. It was coarse joking mixed with sentiments about what was going on at that time. Ms. Barnes and I asked only of each of you, ladies and gentlemen, at this stage in the trial, to just listen very carefully to the evidence and then keep an open mind until you've heard all of the evidence, and then just follow the law that the Honorable Judge Oakley is going to give to you at the end of the case that you are to use to decide your verdict. Thank you.
Ready for witness?
Yes, Your Honor. The people called Timothy Bowman.
Mr. Bowman, all the way up front, watch your step on the incline ramp up here. Would you raise your right hand for me? Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth today? I do. Watch your step on the ramp and have a seat in that chair. Settle in the chair. State your full name for me and spell your last name for the record.
Bowman.
Have a seat. Ms. Manarino, your witness.
Thank you, Your Honor. Mr. Bowman, can you state your name for the record, please?
Pardon me?
Your name.
Timothy Paul Bowman.
Mr. Bowman, are you employed?
Yes,
What do you do?
I am a general contractor.
Other than being a general contractor, do you have any other source of employment?
I'm a supervisor for Sumter Township. Yeah.
How long have you been the supervisor?
A little over 2 years.
I want to draw your attention to August 19th of 2022. Do you recall that date?
Yes.
Did something happen on that date that caused you to have contact with the Sumter Township Police?
Yes, I received a message on my phone.
And how did you receive that message on your phone?
I was sitting on my porch with my wife, and I was strolling through my phone, and I found the message on the phone.
And when you were at your residence, was that in Sumter Township?
Mm-hmm.
Is that a yes?
Pardon me?
Is that a yes?
Yes.
Okay, sorry, I'm just asking for the court reporter.
I'm sorry, I'm
No,
a little
it's
hard
okay.
of hearing.
That's okay. If you can't hear me, just let me know. Was there a particular way that you received that message on your phone?
It was, I believe, Messenger, or it was on my phone, message on my phone.
Okay, is that Facebook Messenger?
Yes.
And when you received those messages, did you know who they were from?
Yes.
And how did you know?
I recognized the voice.
Okay, so there was someone speaking in the message.
Correct.
And was that person speaking male or female, if you could tell?
Female.
And you recognized that voice as someone that you knew?
Yes.
And who did you recognize that voice as?
Miss Sheena Barnes.
And do you see Miss Barnes present in the courtroom this morning?
Pardon me?
Do you see Miss Barnes in the courtroom this morning?
Yes, I do.
Okay, can you identify where she's located?
Behind you over there. I can't see her. Right there.
And what is she wearing for the record?
Pardon me?
What is she wearing?
She is wearing a yellow and black outfit with flowers on it.
Your Honor, let the record reflect that the witnesses identified the defendant.
So noted.
And the When you met with the Sumter Township Police, did you provide them the messages that you had received?
Yes, I did.
I'm gonna. Just 1 second, Your Honor. All right, Mr. Bowman, I'm gonna play for you. I'm gonna play for you what we're marking as People's Exhibit 1. So I'm gonna play this for you, okay?
Okay.
You're gonna end up going back selling Christmas trees. That's what's gonna happen to you. You're barking up the wrong tree with this black bitch. Bring it on. Trust me, I'm gonna be sitting right next to your ass until we get done with you. Recall your ass, all of y'all. Now make sure you let them hear this shit. I'm gonna stick my stick up your ass, and when I get done, Tim, you can find it coming out your wife.
Mr. Bowman, is that a message that you received from Ms. Barnes on August 19th through Facebook Messenger?
Yes, there was a little bit more to it than that. Yes.
But that is the message?
Yes,
Okay.
yes, it is.
And the portion at the end of the message where there's reference to a stick. Did you take issue with that language?
There was reference to what?
A stick?
Yeah,
Did you take issue with that portion of the message?
yes.
And why was that?
When there was reference to a dick, is that what you just said?
Stick?
Yeah. Mm-hmm. Why did I do what?
Why did you take issue with that portion of the message?
Well, it was offensive, you know, very offensive. If I may, the part that bothers me most is when my wife was involved with that. When she talks about sticking a stick up my ass and find it coming out my wife. That's what made me upset.
Did you view that language as threatening?
Absolutely.
Your Honor, I'd move for the admission of People's Exhibit 1.
Ms. Young,
No objection.
all right, that'll come in as Exhibit 1, People's Exhibit 1.
Your Honor, I have no further questions for this witness.
Ms. Young, your witness.
Good morning, Mr. Bowman.
Good morning.
So this message obviously was back in 2022, is that correct?
Mm-hmm.
Okay. And
Yes.
at that time, Ms. Barnes had ran for township treasurer, is that correct?
Yes,
And you were the township supervisor then?
correct.
Okay. And you agree that you were not happy about Ms. Barnes running for treasurer, correct?
That is not true.
Okay. You knew her campaign was based in part on stopping the giving of big raises to township officials and what she believed was going on in terms of overspending and improper use of township monies. You knew that was part of her campaign agenda, right?
She may have.
Yes or no, sir?
No,
You didn't know that was part of her campaign agenda?
no.
I see. You were aware of the article that she wrote that was posted on July 14th, 2022, that mentioned your name in reference to this campaign agenda, right?
Repeat that question, please.
Okay. You were aware of the article that she wrote that was posted on July 14th, 2022, that mentioned your name in reference to this campaign agenda, correct?
My name reference in what matter?
Overspending by the township. Large raises that weren't appropriate, that were being given
Oh,
out.
yes. Yeah.
Okay. You clearly didn't like her campaign agenda, correct?
Clearly, I didn't what?
You did not like, I'm sorry, let me speak up a little bit louder. I'm sorry, sir. You clearly didn't like her campaign agenda, correct?
I wouldn't say I didn't like it. It was untrue.
I see, okay. Now, you were supporting a gentleman by the name of Mr. Vincent Warren at that time?
Yes,
Okay. And however, you knew that Ms. Barnes had a lot of influence in the community, correct?
I wouldn't, you'd have to specify what type of influence you're talking about.
In terms of people respected her, knew what she stood for, etc.
I don't communicate with Mrs. Barnes to know what people or who respects her, who supports her.
Sir, didn't you actually attend, you and your family attend a rally, a political rally, meeting of candidates at her home?
Yes, I did.
It's relevant to the messages.
Well, let's wait and see if it's a relevancy
Okay.
objection.
It is, Your Honor. I mean, I don't know what, one, I don't know when this occurred, but I don't know what time, time frame we're talking about. I don't know that necessarily everything that occurred during the course of an election political campaign is necessarily relevant to the phone message that was communicated to Mr. Bowman on August 19th.
Okay, relevant.
Okay. I can proceed, Your Honor?
No, it's relevant. I want to know what your response to the relevancy
It's
objection is.
because of the message that she left him
Okay.
as to why she did it. This is why I'm going into this area. And it all happened around in 2022. I'm not going further back, but at the time the message was sent, around that time period. So it's relevant to the jury as to why she said what she said.
Right. So how influential she may be in the community is relevant to why she said what she said.
Well,
Because that's the question is,
no,
did you know
my
she was
question was,
influential?
is that he claims he really didn't know anything about her, but yet and still
That's not what he
he
claimed.
attended
But
her,
that's not what he claimed.
attended her rally.
But that's not what he claimed. You asked him if he would agree that she's an influential person, and he said, no, I don't know about her.
And my next question was, and I have evidence, Your Honor, that he attended a rally of hers, a meeting of candidates.
Okay.
And that's relevant.
I'll-
It goes to his character and
I'll
honesty.
allow it, but caution as per prior to trial caution. We're not getting too far in the weeds on
Of
this.
course not. I'm not gonna get too far.
Did you go to a rally?
Yes, I did.
Okay, go
Yeah.
ahead.
Now, you later learned that pictures of people that was at the rally, including your picture and your wife's picture, was posted, correct? Was it the newspaper?
I don't recall them being reposted in the
Okay.
newspaper.
You weren't
I don't-
upset about that?
I don't read that newspaper on a regular basis.
Okay, but you heard that they were posted, correct?
No, I did not.
Okay. Now, with respect to this Facebook Messenger, that's a texting app, is that correct? Where you can both send one-on-one texts
I have no
or
idea.
group texting, is that correct?
I have no idea what it's based on. You can text back and
Don't you
forth.
use it?
Pardon me?
Don't you have it on your phone?
I have Messenger on my phone, but I rarely use it. Yeah, I don't have any use for it.
You've used it with respect to sending messages to Ms. Barnes, haven't you?
Yes.
Okay, I'm just clarifying for the jury in the event they have never used Facebook messaging, how it works. That's all. So my question was, is that it's a texting app, and correct me if I'm wrong, where you can do one-on-one, send messages to a person one-on-one privately, or you can send messages that would get posted to a public Facebook post,
If you
correct?
say that's how it works, that's how it works. I'm not into Facebook Messenger and everything else.
Okay.
I text from when I need to text somebody from my business, but I'm not into all that, you use it for this, you use it for that.
Have
Okay.
you, sir, ever posted a message, written and posted a message on Ms. Barnes' public Facebook page?
Yes,
Okay, so you have used it.
yeah,
Okay.
I faintly know how to use it, but
I see.
I rarely use it.
As a matter of fact, let's talk about a particular post. you were aware that Ms. Barnes publicly posts daily prayers on her Facebook, correct?
Your Honor, I'm gonna object to that relevant.
It's relevant to why she responded the way she did. Because he,
That implies there's a defense to the language you use. What, I'm not aware of a legal defense to this charge.
okay, I will explain the exhibit I'm getting ready to offer, if that will help the court understand.
I don't know if it will, but
That's why
try.
I'm getting ready to make an offer.
Go ahead.
I'm getting ready to make an offer of a copy of a prayer that Ms. Barnes posted, and then it was publicly posted, and then a copy of a written response that he wrote and publicly posted it on Ms. Barnes' Facebook, calling her basically a devil in sheep's clothing, and calling her having demons. It's relevant to why she responded the way she did.
All right, why don't we let the jury take a break? Mr. Bowman, you can stay where you're at. Folks, take a break for a minute. Might as well take them right into deliberation. Yeah. Yeah, and one thing I didn't say is anything you want to leave in your chair, it'll be there when you get back. This room's never empty until we're done with the trial. So purses, coats, if you want to take it, take it. If you want to leave it, leave it.
Was my exhibit one?
The recording was exhibit 1.
Okay, Ms. Young was just asking so she can letter her exhibits.
We can't take them out that way, Ken? Deliberation room.
I'm sorry?
I thought we were gonna take them to the deliberation room. Oh, I'm sorry.
We're all going this way, my apologies.
That'll reflect on his job of Val. Oh, nice. Very nice. Okay, I'm ready to continue. Here's what I'm having a problem with.
Can we Tuesday?
Yeah, that's probably smart. Yeah, Mr. Bowman, take a break. Go ahead, stop stream. You can take a break. I'm kicking you out for a minute.